Beautiful. Well, hello everyone, and welcome to our town hall meeting of the Florida Interest Network. I am Dr. Annalyn Schooley, current chair of the FIN, and today we are in conversation with Lori Caldwell-Carr, who is a family law attorney, and many of us have to work with attorneys in one way or another, and so it's always nice to have a friendly attorney to tell us what in the world they wish we knew about what they were doing so that we can be better collaborators. So Lori, welcome, welcome.
Thank you. Thank you very much. And I appreciate Meredith Neal, who invited me to speak. And she knows that I love working with marital family therapists and really counselors of all types, but I definitely refer a lot to people prior to getting divorced. I tell them, they should be just as sure about getting divorced as they are about getting married. But so let me tell you, a little bit about myself. And I know that picture doesn't look like me anymore. We were just talking about how I need a new picture. But I'm a family law attorney. I'm in Florida. I know some of you in other states, so there is going to be some, a bit of a legal discussion that may not necessarily apply. Every state is a bit different. However, I think in general what I'm going to present is pretty broad-based, that it's consistent with most states. I've been practicing exclusively family law since 2005, and quite honestly, I love what I do. There's a couple things I don't like about it, but most things I really enjoy. Most of my practice involves divorce, some paternity, I do some guardian ad litem work, which I know some mental health people do as well, and I do post-judgment or modification work. So that's kind of the area of scope. I don't really do much adoption or guardianship. I'm pretty much limited to, divorce and family type situations. I did want to give you kind of just an idea of where we're going today, just so you have a little bit of a roadmap. So I'm going to talk a little bit about my work with marriage and family therapists. I'm going to talk a little bit about kind of the divorce roadmap that we use. So, and oddly enough, the acronym for it is PEACE, which seems a little unusual when you're talking about divorce, that's an acronym. I'm also going to talk about resolution options. There's a lot of different options. You don't have to necessarily rush to the courthouse, file a petition, and have somebody served with a lawsuit, which usually doesn't make anybody happy. And we're going to talk about representation methods. So there's different ways that lawyers can represent clients, and I think it's more than just one way. So I want to make sure that I cover that. There's two questions that everyone asks me, and I'm going to go over those two questions. All the clients I have ask me this question, and it's a difficult one to answer. Both of them are. So I'm going to let you know what that is and why they're difficult to answer. And I want to let you guys know, lawyers need marriage and family therapists. We need you guys. So know that, and then I want to have you understand how you can help us, be more effective in servicing our clients and in working with you. So I'm one of those people that always feels like you have to kind of have a philosophy or be able to give people an idea of what you're about. So this is an unknown author, but I've always loved this quote, which is, life is not about finding yourself, life is about creating yourself. And I think from your perspective as marriage and family therapists, you help people create themselves all the time and recreate themselves. And the value that that adds is life-changing. So let's talk a little bit about working together, about how I work with marriage and family therapists. So I'm going to tell you a very large percentage of my cases involve mental health professionals in some form. Whether it's my client has a counselor, there's children in counseling, there's addiction issues, there's, ongoing co-parenting conflict. So I have many cases that involve mental health professionals, and I feel very blessed for that. I tell my clients, just like I said at the beginning, they need to be 99.9% sure that they're emotionally ready when they're going to proceed with divorcing their spouse, and additionally that it's really the right thing to do. And I've referred many clients, I don't know the number, but many to marriage counseling where I've not seen them again. So I'm hopeful, fingers crossed it worked. So that is one of the roles I think of a good family law attorney, is to be able to encourage people to make sure that the step they're taking is they're ready for it and it's the right step. I recommend clients have a counselor to assist in navigating emotional pieces of family law matters. I tell them I know enough about mental health to be extremely dangerous and that they really need to have somebody who's trained in this area to help them navigate the emotionality of the process and to actually be able to move forward in a positive way. So let's talk about peace. This is the acronym. We really use this to make sure that when we are doing our cases, whether it's for court or for mediation, that we don't miss anything. And these are the 5 components of what we look at. We typically do it in this order, and the reason we do it in this order is because they kind of build upon each other. And I'm sure, as most of you would expect, the most important thing is parenting. When we have clients that have children, parenting is usually what's most important to them. And the parenting component is, from a legal perspective, is 2 components. One is the decision-making piece of being a parent. You know, when you're parenting as a married couple, sometimes maybe, you know, one parent picks one activity and another parent picks another activity, but they still share it. And so the goal is, under the law, that is each parent should be able to continue to parent, even if you're not living under the same roof and even if you're not married anymore. There's some few exceptions where maybe if you have somebody with very extreme mental health issues or addiction issues, that one parent may have either what we call ultimate decision making, meaning they still try to agree, but if they can't, they get to make the choice, or sole decision making, which is very, very rare for one parent to just have all of the decision making authority, but it does happen sometimes. The other thing with parenting is the time sharing piece. The time sharing component is, you know, where the children are going to be when and what the holidays are going to look like, and some of the additional things like what, you know, where, when can they travel, where can they travel. It's all of this is done through a parenting plan form. So I'm going to move on to that one. So again, the parenting plan form is a Supreme Court form, and it's 12.995A. One of the things I really like to do is to refer my clients to work with mental health professionals, and marriage and family therapists definitely fall into that category for people that I refer to do parenting plans. It's a form, and I use the form. Most lawyers use the form. But the problem is, when you're a lawyer, you draft the document based upon what your client wants, and then you send it to the other, you know, party's attorney, and they look at it from what their client wants. Is where, if they go to you and sit down together and talk about what's best for their children in a joint meeting with one person, and you have the experience or the resources to understand developmental ages of children and special needs of children. Maybe you have a child that just doesn't deal well with transition. So, you know, a schedule where they're with mom Monday, Tuesday, dad Wednesday, Thursday, and every other weekend may just be too choppy, you know, and you would know those things. I don't know those things. So I always think if parents have the ability to sit down in a room together with a mental health person to complete this parenting plan, that is a huge gift to their children. The one thing I do want to make everybody kind of aware too is, I know there's a lot of discussion about, and here's one of the things I really dislike about what I do, which is that the time sharing, the number of overnights each parent has, directly correlates to child support. So unfortunately, as much as we don't want to think it, there are parents that fight for more time because then they think they're going to either get more money or pay less money. And it's a shame that it has to be that way, but that's the way the calculation works. But since I started doing this work in 15 years ago, 2005, there was a strong presumption that the children would be with one parent more, which was usually the mother. And it was usually that a dad would get every other weekend and one night a week, and the rest of the time they would be with the mother. Well, since that time, there's been a strong movement towards, if you have 2 parents that have kind of an equal work schedule, equal availability, and equal, you know, acronym to care for the children, that it should be more of an equal time sharing schedule. So that's definitely something that's happening, and it's good for the clients to kind of be aware of that. So these are more financial issues. I don't think the financial issues impact the mental health people as much as the parenting issues, I'm guessing. However, that doesn't mean there's not emotion around the financial pieces for many people, particularly if in an area like equitable distribution where you're really just taking all of the assets and the liabilities that are incurred during that time of the marriage and trying to figure out how to divide it. You don't have a person who, say, has a lot of trauma over losing a home, or somebody who has a lot of concern about the fact that, during their working life, they've invested a lot of retirement money that now is going to have to be somehow shared or divided. So there is a lot of emotion for many people around their things, their stuff. But that's equitable distribution is really just the division of all of the assets and liabilities during the term of the marriage. People do get very emotional about alimony too. Everybody feels like they don't really want to be paying it, and the person who's receiving it usually feels like it's a need, and that's what the law says. It's based upon one party's need and the other's ability to pay. Alimony is constantly under fire these days. It's one of, I heard you guys talking about legislation and, things that you're getting passed. Alimony's been constantly under battle in Tallahassee since 2011. It's a pretty complicated area. It has multiple different types of alimony. There are factors you have to argue, and it's very financial based, based upon the expenses of the parties and the lifestyle. Child support is a calculation. That's one of the few things that's pretty easy. And, we do the parenting plan because that gives us the number of overnights. We do the alimony or that support so you know what the income of each parties are, and then there's a credit for either health care or child care. So that one's pretty easy. Everything else is that broad net of what's specific and unique to every person. I mean, so those are things that, who's going to get the dog. I just did a case where we literally did a time sharing schedule with the dog because that was really, really important to both people, and they agreed that that was in the best interest of the dog. So I think the everything else category is sometimes also a very broad area where I get a lot of support from mental health counselors and helping me A, identify them, and B, be able to figure out creative ways to allow the parties to transition without acrimony. So I'm going to move on to just some more of the actual different types and methods for divorce. So one of the most underused tools, in my opinion, is a simplified divorce. There's statistics that show that only like 11.4% of the divorces statewide, are really using this method. This is for people that don't really need an attorney. It's a very specific type of divorce, and I'm telling you this because I think maybe you have some, people that you work with as your clients that would be this would be a good tool for them. So they have to meet all of the following requirements. So there can't be any minor children, and the wife or the mother can't be pregnant. The couple's already agreed to the terms of the divorce. There's no alimony, and the couple jointly file for divorce. So they must jointly appear at a final hearing. I think now they're doing those hearings primarily via Zoom. But it's very easy. There's no attorneys. It's little paperwork. And it's really, 11.4, I guess, is pretty high based upon the fact that it's not very well publicized, but in my opinion, it should be higher. And I have people come to me and I'm like, you just need to do this yourself. I can give you all the papers and stuff, but you don't need an attorney. You should just do this yourself. So I like to make people aware of that option. So here's the options where attorneys get involved in general. Kitchen table, it's just like you would think. It's two people sitting down at a table together and finding resolution by working cooperatively. And I call it kitchen table because often it's at a kitchen table. And they write down the terms. I usually tell my clients, sign the piece of paper, and it doesn't really have any legal binding, but for some reason, when people sign that piece of paper, they're more likely to sign the contract, which is the marital settlement agreement when I draft it. So in that process, one lawyer drafts, they usually, you know, the other party's recommended to take it to an attorney for review, and then the agreement is done and drafted, and the other necessary documents are filed, and it's a pretty simple, easy process. The next one is cooperative or offers of settlement, and this is cooperatively trying to reach resolution. This can be with the help of an attorney, it can be without an attorney, but it's really any form of, whether it's, you know, two parties and two attorneys sitting in a room together. I've even done some of these with mental health people, almost like facilitators, or just sending written offers of settlement back and forth. Another one is mediation. I'm sure everybody here has heard of mediation. It's pretty well known. It's required in all of the counties I practice in, which I practice in 5 counties in Central Florida, prior to going in front of a judge for a litigated matter. But it can be, again, done with or without an attorney at any time. It's procedurally required before trial, but you can do it before you know, even start any process. You can go to mediation. Mediation is positional bargaining, so it is a negotiation process, and I tell my clients sometimes it's kind of a little bit like a game, because you're going to offer less than what you're really willing to give, or you're going to ask for more than you really are willing to take, and then you meet kind of in the middle. I've worked with many mental health professionals as mediators that are very well trained. I don't know if any of you are interested in being mediators, but we don't have enough in our area, I don't think. Marriage and family therapists that are trained as mediators. I use the mediators that I use that are in this area for primarily parenting issues, but for the right case, a mental health mediator beats the pants off a lawyer any day. The next one is a collaborative process. I want to be really clear about this. I think people get confused between the collaborative process and cooperative. Collaborative process is a very specific legal process, and it's defined by Florida statutes. So it's in general a team of professionals that are trained in the collaborative process, and we're very blessed. We have a local group here called the Central Florida Collaborative Professionals, and we have a state organization, the Florida Academy of Collaborative Professionals, and they do trainings. So I think there's a training here in August at Berry, but the process has a mental health neutral who really keeps us all on task. They're the ones who keep us in the process, and 2 lawyers that are trained, and a financial neutral. So this one, rather than being positional bargaining like mediation, is very future focused and goal oriented, and we constantly try to move people in the direction of resolution based upon those goals. Sometimes that means we get bumps in the road. The major requirement with collaborative is if you can't resolve collaboratively, then everybody agrees they're going to go get different attorneys, because you want your attorney to have skin in the game. You want them to, you know, be working to help this settle. And then the last option is litigation. It's the traditional process that many people think of when someone, you know, files a request with the court for a divorce. This is where the court literally has a lockstep method of how you're going to get through the process, and the judge makes the final decisions on any issues that people can't agree upon. So all of these options have pros and cons. I tell my clients there's not a one-size-fits-all, and there's times when we kind of go in between different options. We'll talk about that a little more. So in my world, there's only 2 options. The only options are the parties agree or the judge decides. So cooperation and the ability for people to cooperate with each other is highly important when we start talking about different options and the pros and cons of that option. So if someone comes in saying the opposing party in this case will not cooperate under any circumstance, that makes our choice of options really pretty easy. Unfortunately, we're probably going to file a petition and we're going to follow down the litigated road. With that, I want to tell you still a very high percentage of cases settle in mediation. The last Orange County statistic I saw, I think said it was like 18% of, 8% of all cases go to trial. So that means all the other rest are settling at mediation or in some other collaborative or cooperative manner, or they're doing simplified. A lot of people can't even afford attorneys. I think a very small percentage, again, maybe it's like 18 or 20% actually can even afford attorneys, so they're doing it themselves. Cooperative situations are likewise fairly easy to make a choice on options to proceed. I mean, we could do, if they think they're cooperative, we could do a four-way sit down, with the clients and the attorneys. We could probably send a really good offer of settlement. I usually tell my clients I don't like to send offers of settlement unless they think there's an 80% chance or better the other side will accept, just because then we kind of lose that whole positional bargaining side. But cooperative options are usually pretty easy. Where it gets really difficult is when my client doesn't know how the other party's really going to be responding. They don't know. So then we have to kind of compromise. Do we, take the risk of maybe wasting time and money to try to cooperate and sending letters and trying to, make a nice cooperative type process? Or do we just jump straight into, filing the papers, having them served, and then pull back to more cooperative? Those are really hard discussions to have with clients, and they're really hard choices for them to make. And again, that's where mental health people can really help, work with them to kind of take, and there'll be times I have handouts that I give my clients. Yeah, I still do paper. And I will tell them, take this to your mental health person and ask them how they think this would work. And that's really helpful to them, because these choices aren't ones they just want to make or they shouldn't make quickly. So I think I mentioned a little bit earlier, one of the nice things is that you can change your process. You're not stuck necessarily in one process. I've had cases that have started out very cooperatively. I've even had cases that have been collaborative, that for some reason there's a bump in the road or something happens and they become litigated cases. And I've absolutely had litigated cases that at some point, everybody sits down and says, you know what, we're really not that far apart, and they become much more cooperative. So this is an ever-changing opportunity to look at different options. Settlement is available at any time before a judge rules on a case, and the saddest and hardest thing for me is when I have a case that I prepare for trial for and I'm ready to go and we're walking in the door and it settles, and I'm like, okay, well, I guess at least it settled, but it's too bad all that money had to be spent and time taken before we could get there. So here's some representation methods, because I think sometimes mental health people think that lawyers, we're just there to go litigate, go to court, and that is part of our job. I'm not saying that it's not, but once a party's kind of picked an option, then they need a method. They need a method to get through it, and there are many choices for people to get through the processes. And here's just 4 of the primary ones that, I recommend and talk to clients about. So one is do it yourself. And it's just like it sounds. I mean, there are a lot of people out there that are doing their own divorces. And it's very common in family law that people are able to do their own divorces. We have very good Supreme Court forms that were created by the Florida Bar Family Law section, and they're good. They can get them done. I think the hardest part is navigating the different courts processes, how to file it, how, if it needs to be served, how to get it served. So that's where it can be a little bit more daunting. With that being said, a lot of lawyers, I know there's quite a few really good. We're blessed. We have a lot of good family law attorneys in the Central Florida area that will do legal coaching for people that want to represent themselves, but they really want just somebody to help them, figure out the roadmap. So they hire us just as coaches. So they do everything themselves, and they appear on their own. So it's on request. They're meaning the client is fully responsible for their case at all times in a coaching relationship, and the attorney is not proactively managing or monitoring the case. They're just helping them with specific issues as it relates to the legal venue they're operating in. Limited scope. These are becoming more and more popular because it's a very defined area that a lawyer is going to be helping a client in, so that it's much easier to know what that is going to cost. One of the things I stated at the beginning is there's two things I don't like about what I do, and one of them is I can't tell people how much it's going to cost. To me, that's just crazy. What do you buy that you don't know how much it's going to cost? But the reality is I don't know who the other attorney is going to be. I don't know what financial documents at the beginning I'm going to be dealing with. So, we do everything we can to try to, limit acrimony and expense, but it's just hard. You can't tell somebody exactly what it's going to be. So the limited scope is nice because you can hire somebody just to go to a hearing for the limited purpose of going to hearing, or maybe for the limited purpose of helping you prepare and attend mediation, because since mediation is so important and that's where cases settle, maybe that's where you want to put that time in. Or maybe you need an important document drafted. Maybe there's a really important document that needs to be drafted that you really want to have an attorney do. So in that situation, the attorney does take responsibility for that limited scope work, and the party maintains responsibility for everything else. So it's kind of a good hybrid. And then there's the traditional model, which is the full representation, where you hire the attorney from beginning to end. Typically, there's an upfront retainer, and then there's replenishments based upon work as it needs to be done. So with that transition, we're going to the two big questions. The two big things everybody wants to know is how much, how long? How much, how long, how much, how long? And it's not how much, how long, like how much are my fees? How long is the process going to take? How much am I going to get in alimony? How much am I going to get in child support? Or how much am I going to pay for that? How long am I going to get that? So it's about almost every factor. But it's usually immediately followed by their circumstances that have little to do with cost. So it's kind of always interesting to me. But that's what they want to know. And I think it's probably from a mental health perspective, the marriage and family therapists understand this better than I do. I think they just want to understand what the closure is going to be. I feel it's much more of an emotional issue than a legal issue. So this is hard. These are hard things for me to answer. And as much as I want to answer it for them, if what it is going to be for an uncontested matter with agreement of the parties, and that's simple. I mean, I can probably do you a flat fee quote, but in general, that's not what we're talking about. So let me tell you why it's so hard and why the variables are there that are so hard to make these questions easy to answer. So costs are primarily related to conflict, which is what you guys deal with. This is how mental health people can really help lawyers. If you can help them have maybe a bit of a more grounded reality check about the cost related to conflict, which is the inability to reach agreement. And I know everybody thinks that their spouse or soon-to-be ex-spouse is the one who drives up the cost, and they're the ones who are crazy, they're the ones who are being unreasonable. But usually there's some kind of combination of both. It's rarely all one side. But anything that is beyond a flat fee is going to be partially driven by conflict. It tends to be the biggest driver of cost and time. The second is the level of cooperation. So if you have parties that are going to cooperate, that's going to make it so much easier. A party, who's really just not ready for the process is going to, lots of times are going to try to figure ways to stall it out because they're just not ready to be done. And that's sometimes being uncooperative, that's sometimes not responding to timelines, which then increases costs because you may have to file a motion to compel the documents you need to even be able to figure out what the assets are, and you have to go to court for that. And so I think that's definitely an area where my clients that have mental health professionals involved, I try to have them work out with in their sessions what the roadblocks are, why they aren't able to move forward. Then the final one is one that just seems so basic to me, but if they don't have a plan, if they don't have a vision of what their future is going to look like, they often are unable to even make a choice. They're like frozen, and they're unsure of what they want, and they keep changing their mind. And these are issues that can come from either or both sides of the parties. I mean, the number of times, and I'm sure you as marriage and family therapists have heard this too, where they're divorced, they're getting divorced, they're definitely ready to get divorced, and then they get together. I mean, they sleep together. I'm like, so what are we doing? I get very confused. And then they wonder why the other person's confused. And so these things are nearly impossible to predict. And the impact of these items make it difficult to predict cost and along with that, the amount of time it's going to take. So again, I think I already kind of touched on the trends of moving more towards the equal time sharing. I think if there's one part of it that is concerning to me, and it's from my guardian ad litem work more than my lawyer work, is there are 20 factors in the law that the courts are supposed to look at in the best interest of children. It seems like that with some of the cases I've been working on, that the trend is almost more towards the rights of the parents to be able to have this equal time with the children than it is in what's in the best interest of the children. So that trend is a little bit scary and maybe upsetting to me personally, but it just does seem to be going that way. And I think it's a good thing for marriage and family therapists to know that for families that are looking to, possibly separate, that could be a reality. The other thing is alimony. Alimony is under regular pressure to change legislation as it relates to both the 8 factors and the types and terms. A new term was added in 2011. And on December 31st, 2018, there was a big federal tax law change that changed alimony from being taxable to the receiving party, which was typically a benefit because a higher income earner was willing to pay more for alimony to the lower income earner based upon the fact that they weren't paying the taxes on that. So it was transferring the wealth from the higher income earner to the lower income earner and keeping more money within the family. But now the law changes that it's after-tax dollars are paid to the receiver. And though that may seem like a benefit, typically it's not, because in negotiation, the payer is going to be willing to pay less at the end of the day. At least that's my experience. So here we are, things attorneys would like you to know. So most people represent themselves in family law cases. That's normal. So you all may see more people that are going through divorces than I do. That sounds kind of crazy, but it's true. Trial is unusual. So typically, and I said 8% before, I think so this is 6.9 of the divorce cases go to trial, and that was statewide. And I was doing Orange County, so I guess Orange County is a little higher. But most cases don't go to trial, and the reason is trial's really expensive. And I literally tell my clients the definition of insanity is to pay a lawyer more than you're going to pay or get from the other person. Understand, even though that we don't have trials, there may still be some hearings that you have to attend in front of a judge, but full trials are fairly rare. Yeah, so trials are unusual. So that means most cases settle. And the only way to avoid a trial is to settle. So if few cases go to trial, the vast majority do settle, and that's a good thing. And I think most of them probably do settle at mediation or as a result of mediation because of the requirement that everybody go to mediation before they go to trial. But I know that many cases do settle as a result of some type of a cooperative or collaborative venue. So I'm going to tell you, I bet you guys know more about family law legal advice than the average person. So just be careful. Don't give legal advice. Just be careful. Also, avoid kind of setting expectations that something is certain. Don't tell the clients obviously what the law is. Instead, explain your understanding of something. And be careful applying, and I have to be careful of this, applying what happened in one person's case with another, because every family is unique and different. And refer them to a trusted family law attorney. I mean, there's lots of us out there that, will do consults. I mean, most of us charge something for them, but my goal is when somebody comes in for a consult, they pay for 1 hour of my time, but my goal is they're going to walk away with true information. And my consults are usually an hour and a half to 2 hours. Family law is very, very circumstantial. So what worked for one person doesn't necessarily work for another. I will give clients examples, but I try to give ones that are pretty broad and that don't really project any given outcome, because that's very hard to do. There's little certainty in family law. There's rarely black and white. Judges, if you do end up having to be in front of a judge, they have very broad discretion to do what they think is appropriate. They want to do what's right, but we all operate with bias. So they bring in their own bias and they impose that on what they think is right. Now, of course, it's based upon evidence in the law, which we're going to talk about next, but they still have varying outcomes, and it's very circumstantial. And they have good days and bad days, just like we do. They're people. So the other thing that I want marriage and family therapists to know is attorneys need evidence. We need evidence. So if you could help your clients, if you know that they're possibly heading down that road, that they need to keep records, keep calendars, keep, I tell my clients, if I need to be, I can be the hammer, but you've got to give me the nails. I can't help much without nails. So this means gathering and maintaining evidence. He said, she said in court is very difficult from a legal situation. So they need to gather and maintain documents and evidence. One of the major things that can help me, and I know that a lot of my clients have had their therapists work with them on this before they even come in to meet with me. I can just tell. So they need to have a plan, and ideally they need to kind of have a short-term plan of what it's going to look like during the process, and then they need a long-term plan, something that if they ran into one of us at the grocery store and actually acknowledged us, they would say everything went just the way it was supposed to. This is how I've got my retirement up and going. I got the house. Our kids are doing great. We're co-parenting well. So this is particularly creating a plan is such a wonderful place where marriage and family therapists can absolutely help set them up for success moving forward. So FAIR is kind of what I say the four-letter F word for family law attorneys. We don't use it. FAIR is subjective. So I don't let people or my clients use it to describe legal matters. The closest legal concept we have to fair is equitable, but that does really not mean fair. So I try to steer my clients away from that concept and get them to understand that we have to get it to a place that is equitable. So the legal system's limited. It makes decisions for people when they can't or won't decide themselves, or it punishes them if they have bad behavior. But in reality, the legal system can't make anybody do anything. Even when I have cases where I've had clients where they've not received child support for years, if the person doesn't have the money in a bank account or something to sell or a expensive watch for the judge to give to my client, they're not going to put them in jail. There's no debtor's prison. So there's really not a whole lot a court can do to make somebody do something else. I always like it if possible, if I can speak with mental health people. I know sometimes they will and sometimes they won't, but if you can get permission from the client to talk with the family law attorney when you think it's appropriate, and I'm sure that's not under every circumstance, that can be really helpful. It helps me from the standpoint of sometimes I have clients that I don't realize maybe a certain phrase I use or a word I use is, not hitting with them right, or there's something I'm doing that seems odd, and so it's helpful for me to learn how to talk to my clients, but then I think it's also helpful sometimes for the mental health people to understand where there's kind of being bumps in the road and why. So, and sometimes, when I have these conversations, things aren't what I expected, and I think this also what the mental health person didn't expect either. And I think we all just want to help. So one of the major things, and I know almost all of the wonderful mental health people I work with know this, is that clients really have to understand they only have control over themselves. They need to understand how to work, with difficult situations. And rarely will the legal system make people behave or do things a certain way. And rarely does everybody get everything they want. It's going to be a compromise. And the goal is to be able to transition in a way that, you can live with what you're moving into. So we need you. Attorneys need you. We do. So all of our clients need counselors. They all do. Maybe not the kitchen table ones, but otherwise, they need individual counseling. They need family counseling. They may need reunification counseling, but they need counseling. And you're the glue. You're the ones that stay there with them. The goal is, you have a lawyer for a period of time, and then hopefully, really, you never have to see them again. So that's really important. And I think all of, my colleagues that I'm blessed to work with feel the same way. Here's some other roles that I know that mental health people work in and that there's a need for. Guardian ad litem work, which is clearly defined by statute, and I've put the statute here in the PowerPoint. It's an investigator. You're appointed by the court to go out and interview people and speak with the family members and write a report. They're based upon the 20 factors to make a recommendation. You don't make decisions, you make recommendations that are in the best interest of children. I took the Florida Bar training. I do some of this work as a lawyer. I think some cases lawyers are better suited for, some cases mental health people are definitely better suited for. It's hard work. I probably do 6 to 8 of them a year, but I know I enjoy them because I know I'm on the right side. I'm always on the right side in those cases, but they're tough cases. Parenting coordinators. Oh my gosh, I love parenting coordinators. I don't know if any of you do parent coordinating work, but it's defined by statute here, 61.125. There's some attorneys that say, oh, parenting coordinators don't really help, which I think is totally wrong. These are folks that mental health people that really help people co-parent and learn how to communicate with each other in a different way and allow them to understand that it doesn't matter whether she wears the pink bunny suit or the blue bunny suit for Halloween. So this is what keeps the parents on track to do what's right for their children. Social investigators, I know they require a higher level of training. I know there's testing involved. It's usually where there's really high conflict cases where there's some mental health concern component. They do some of the same work as parenting coordinators as far as investigation, but they more focus on testing. And it's usually when, again, you have some kind of concern about addiction or mental health, a severe mental health issue. A huge need right now is supervisors for time sharing. I know a lot of people aren't interested in it. It's primarily just watching for behavior when there's a concern about one parent maybe not being able to know what to say and not to say. They're ordered by the court in situations where there's a concern for primarily what a parent says rather than what a parent does. And there's been a lot of them being done virtually now, but they're sometimes in person and sometimes they're just telephone monitoring. And the other one I already talked about was parenting plan creators. I really do, I'm very happy when I can have a client that I know has the ability to tolerate and productively sit in a room and speak with each other about a parenting plan with a mental health person. And I think those plans are much better. They should always be given to a lawyer to review because there are legal components to it, but in general, the important stuff like, what holidays, the time sharing schedule, what activities, when they get a cell phone. I don't know, a right age to give a child a cell phone, when do they get a car? These are all things that I think are just so good to be able to do with a therapist or a counselor. Again, I already talked about mediators. There's some wonderful therapists that are mediators. And then collaborative process neutrals. So I talked about that a little bit too. If you're interested in the collaborative process, you really should research it a bit. There's also a really good international organization called the International Academy of Collaborative Professionals. They have some good information. Okay, so we need you, but sometimes we don't know when or how to work with you. Sometimes we're just confused. So this is how you can help us, help us help you. Have websites. If you could have a website, and it doesn't have to be fancy and it doesn't have to be expensive, just something that we can access that has the types of services you offer, the types of insurance you take, or maybe you don't take any insurance, your pricing, a little bit like I said about what's your philosophy, what's your approach, what makes you different, do you really like working with teenage girls? Do you really enjoy, working with couples that, are going through trauma? What is it you really enjoy? Do you work with addictions? Let us know what it is you do so that we can send the right kind of work to you. Appointment hours are good to know as well, and probably now in this world of COVID, do you have the technological ability to do Zoom? Are all of your meetings now going to be telephonic? So just give us some ideas of when our clients can see you. And absolutely, I know a lot of you work a lot and have people in front of you all the time, but I know clients are always looking for weekends and evenings, and not that people want to work those, but if you have them, please put that up there. Describe maybe some of your experience helping people in family law matters. Have you worked with a lot of families going through divorce to help them transition in a positive way? If you want any legal appointments from a court, like a guardian ad litem or a supervisor or a parenting coordinator, have a resume and make it easily available, because then if I go to court and I need a guardian ad litem, I've got, oh, here's a great one, this is who I recommend. And understand when there's needs for these types of higher level parent-based people, the judges want to get these people appointed quickly. They want them done quickly, and they want the children out of pain. So if I go with a good recommendation, many times that person's going to get appointed. So also, you need to help us. I'm still confused, and I've worked with mental health people for quite a period of time, but sometimes you have to tell us what all those letters behind your name mean and how that makes you different. So if you can kind of put that on a website, that's always helpful. Also, even though websites are good, consider a brochure or a printed page about you, and maybe some of the legal related things that you've done for attorneys, if that's an area that you kind of want to expand into. Because I still hand out paper to people. I mean, not right now because nobody's coming in here, but I still have paper that I hand out. So help us to help you. We want to get to know you. Come get to know us. So come to some of our legal functions. Lawyers aren't so bad. We're really pretty nice. There's many bar and multiple disciplinary groups that meet regularly. The Orange County Bar Association has a family law section, and we even have members, non-lawyer members. So we have mental health and financial people. I think I already told you about the local Central Florida Collaborative Law Group. It's an interdisciplinary group with mental health, and not all of the mental healths are neutral. Some of them are there more for the, ability to be able to be a supportive, counselor. So, come and meet us. And we have great organizations in Central Florida. We're really blessed. Invite us to your functions. If you guys have a function, I mean, like I said, I was so excited when Meredith asked me to speak to this group. And, when I'm invited to go to other organizations, I mean, I get tired of talking to lawyers all the time. I really like mental health people. So it's fun to me to go out and talk to people that do work like I do from a different perspective. I mean, we're all there to help families, so let's talk to each other. Call and have a chat, coffee or lunch. Yeah, we have to eat. I was very impressed. There was a mental health person that I didn't know. She'd started to practice, and she called and just wanted to come over and have a cup of coffee with me and the other attorney who works with me, and this was pre-COVID. And she came over and we talked for like an hour, and it was the most interesting conversation. And absolutely, after making that connection and understanding kind of what her, what she was about, because she kind of had a specific niche of what she did, I've referred people to her, without a doubt. I've referred people to her. So just explain to us, how you can help our clients, and explain what's the difference about you from other marital family therapists. Take some good training about the law. It's good just to know about it. I mean, this is a simple basic one, but it doesn't have to be something that you're getting a CLE or some kind of credit for. I've taken my share of mental health, definitely related type trainings, and I've always enjoyed them. Educate attorneys about helping clients with difficult situations when and when to refer. I mean, we kind of need to know too, here's some warning signs. I mean, I don't always know that, a client may be acting in a certain way, and I think, well, gosh, she's awfully angry, she's awfully hostile, and no, maybe she's been abused, or maybe she just is overall distrustful. So these are things that we're not always good about identifying because we're thinking about all the legal things that we feel like we need to be answering. So I think we're at the end, and I don't know, my watch doesn't want to respond, so I don't know if we have time for questions. I told Meredith that I would be happy to answer any questions
We
that
sure
anybody has.
can, Lori. We sure
Yeah,
can.
yeah.
We've got exactly 10 minutes. Your timing of your presentation is perfection. So you
Well,
said it
thank
was
you.
50 and you rang in right at 50. You're ready for your 20 minutes in front of the Supreme Court. But so yeah, we do have a couple of questions.
Okay.
The first one was, in general, no matter where you are in the state, where might we go to look for mediation training? Is there an organization, or what would we do to get mediation training?
So yeah, there are most of the mediation training, at least in the state of Florida, are done by private trainers.
Mm.
You definitely can find it in Florida, through the Florida Bar. We have a mediation section, I believe. I know that the family law section has a alternative dispute resolution group, which is very active, the Florida Bar Family Law section. If anybody wants that information, or I can send it to you and you can get it out to the members. But I would imagine mostly all the bars in every state, their family law section has some kind of alternative dispute resolution group. And some of those people are trainers and some of them aren't, but they would know where to get the training. We have regular advertisements for different trainings coming up in our Florida Bar News, which comes out monthly. So the bars would be a good place to start to get the mediation trainings. And they're different in every state. The mediation training and the mediation, keeping your mediation, because there's a lot of requirements to keep up your mediation, are pretty tough here in Florida. I mean, I think I had to do like 30 hours of observation to become a mediator. And then I have to take a certain number of CLEs in different categories like domestic violence. And they're very rigorous about it here in Florida, which I think is appropriate. I think it's appropriate. So, but it is different in every state, that I do know. But I would check with your local, maybe start with your local bar, whatever county you live in whatever state. And if they can't give you information, then check with the state bar.
Okay, awesome. Awesome. We also had a question when in looking at divorce and working things out. Is there such a thing as sibling rights?
So by sibling rights, are you talking about from the standpoint of not separating siblings? Is that primarily what the question's related to?
It's a great question. Richard, if you want to come off of mute,
Yeah.
why don't you
Lori,
explain your question?
Lori, that's my question. I'm a guardian ad litem,
Uh-huh.
and one of the cases that I worked with earlier had conflict, and it had to do with whether or not, uh, I guess it was the adoptive parent uh, could practice some sort of safety when it came to sibling. For example, she would arrange Sunday afternoon get-togethers with the two siblings, and the husband would show up drunk, and so she would go, "Can I stop, having sibling interaction because it scares me when he shows up drunk or whatever." And I had no idea what, she eventually ended up adopting the kid. But my question, but philosophically, she believed that the two siblings should, have some kind of interaction. And I never knew what to say to her about what to do when, her belief was that she was putting her family at risk, by allowing this to happen. So that's kind of what the question is.
Yeah. So in general, I'll just tell you from a court's perspective, they're going to try to keep siblings together. So there are very rare situations, and I can think of two off the top of my head, where one parent wanted to keep one child or one group of children, and another parent wanted to keep another group of children. The courts are they typically want the siblings to travel together. if there's an absolute agreement that between the parties that one parent is going to keep one child and one's going to keep another, a court would probably agree to that. They would probably support that if that was the parents' agreement. I think it would be very hard to get a ruling from a court saying that that would be in the best interest of children, because usually there's a belief that children should be together. As far as in that situation, it sounds like if the children weren't together all the time, there was some type of agreement that there was going to be a period of time where they got together, and the parents, it would seem, in our world, would be the ones to make those choices and decisions. And could a parent say, well, I really don't want to partake in that unless it's something ratified by a court order that says this is a, separate time. But here's an example. So in parenting plans, quite often, when you have, say you have 2 children, there'll be a parsed out section in there that will say each parent will have, 1 day a month with one child to spend with that one child, just to be able to have some one-on-one time with that child. So, and that gets ratified by an order because it's part of a parenting plan. So I would assume if one parent said, no, I'm not doing that anymore, then there would be an opportunity to file a motion for contempt and ask for makeup time for that. But there's really, I'm not aware of anything in the state of Florida that's quote unquote sibling rights.
Interesting. Yeah. And of course, Richard, your example was in the case of a child being adopted, and I'm assuming the biological father was the one that was demonstrating why his rights were being terminated by acting in this fashion. So that's a whole other that those kinds of cases tend to go through the child welfare system, and the attorneys that are assigned to that system for those kinds of foster care and adoption issues. Though there are, I assume, private adoptions that happen, and that's a whole other thing, and probably not then related to additional dependency, child abuse, neglect kinds of issues.
Yeah, and guardianship is just an entirely different world.
Yeah.
Yeah, things happen in the guardianship world that, usually don't happen in the regular family law world.
Yeah. Okay, that's great. Richard, thank you for both of those questions. Does anyone else have any questions for Lori before we thank her for her time? And so while someone is maybe typing something into chat for me, we see here that you're providing your phone and email. So we don't necessarily want to inundate you from all over the state with calls and questions. But if someone is trying to find an answer, they've already tried their local bar, they've already tried the state level bar, and that kind of stuff. Could you share any other trends in family law? So you were mentioning a number of trends, but anyway, to finish my thought, we would suggest, if you're listening to this, that if you've tried all other methods, including contacting your local bar and local marriage and family therapists, other therapists, and you cannot find what you need, maybe shoot Lori a quick email.
Absolutely.
You can send us where we need to go.
Absolutely, yes. But just be prepared. If I have your email and I have a question for you, you might get an email back.
Well, there you go. It might be a conversation. That's right. So Meredith asked, are there any other trends in family law that you'd like us to be aware of?
So I think that a lot of the trends, at least that I'm seeing from the courts more, is the judges now, particularly again in Orange County, and not that it doesn't happen in Seminole and Brevard and some of the other counties I practice in, but the judges particularly are wanting to get cases settled. They're doing what's called now more often a case management conference, which they call on their own. If they see a case kind of dragging or stalling, or they see something happening that they think is not appropriate or not moving at the speed that they think it should move at, that they do a little nudge to the lawyers. They reach out to the lawyers. And I'm interested, I don't know, because I don't know what happens with unrepresented people, and I'm always very curious about that. But I don't know if they do it with the unrepresented parties as well. But they will set a time where we have to either do a telephone or a Zoom. They usually don't make us come in for a case management conference. Sometimes they do, if they, I guess more if they want to more if they're upset about something and want to finger wag at us. But they'll call us in and they'll say, okay, so what's holding up this parenting plan? You know, why are we not getting this parenting plan done? I see everything else is filed in this case. It's ready to be done. Why don't we have the parenting plan done? And then if they realize that it's some kind of conflict between the parties, I have a case like this actually right now, and they appointed the judge out of her own volition, and she has a perfect right to, no motion, no request by a party, appointed a parenting coordinator and said, okay, you will get these things done. You will have, 60 to 90 days to get it done. And lo and behold, it didn't get done. It didn't get done. These two are hard work. The parents are hard work, not the kids, the parents. And so she set a case management conference then with the clients and basically told them, I'm just going to tell you how I would read. This is what I would do if you came into me for a trial. So you guys may want to get this settled. So I see a trend in the courts, especially with family law, and I don't do other areas of law, so I don't really know what it looks like in other places, but really trying to support agreement. I think there's a lot of studies in the mental health field that I understand, and I'm sure you all know this, that the likelihood of people complying with agreements that they create on their own is much higher than it is with ones that are done by judges, by ruling of a court. And the reason is because if it's their own agreement, they're much more empowered to follow it, even if there's things about it they don't like. So I think the courts are getting that, and I think we're pretty blessed in this area to have really good courts. We have good judges in general. So that's definitely a trend I've been seeing quite a lot that makes me happy.
And it also sounds like that's a trend that would get us as marriage and family therapists involved in helping that process.
Absolutely.
So that is
Absolutely.
great to know. That's really, really great to know.
Yeah.
Awesome.
Absolutely.
Well, again, we want to thank you, Lori, very much. For those of you who are listening to this and maybe found us on our YouTube channel at Florida Interest Network, we do these with some frequency. If you would like to join to hear about what we're doing and when, go to aamft.org and join as whatever level member you can. And then you can also join the Florida Interest Network at a very low cost and be in on the loop for these things. But otherwise, I hope you've really enjoyed our speaker today. So to everyone here, thank you very much. Great to see how many of you snuck in while we were working. And Lori, thank you again. And we may have to have you come back, once a year, let us know what's going on. So so easy to understand, very clear. Appreciate you so much.
Well, thank you for having me, and everybody be healthy and be safe.
That's right.
Okay.
Good night, everyone.
Bye-bye.